What's up, guys? It's Andy with MrAndyBuysHouses.com, and today I'm here with Andrew Gurvey from the Gurvey Law Group. When I tell you that this is one of the best attorneys here in the Atlanta, I've been closing several crazy deals that I don't know. One of? Man, I'm telling you which one. All of them have been crazy, title issues and everything. But today, Andrew's going to be talking to us on, 5, 6, how many issues,
We'll get to them.
We'll get to them. 5, 6, 7 things you have to have on a real estate contract, guys, okay? In order for it to be what? Viable? Real? Valid. Okay? And so, Andrew, just take it off from here, because you do have, wait, before we get started, on your website, you offer people to download a fully vetted contract that's been vetted by you through the web. Anyways, we'll get that. Stick out to the end. I'm gonna show you how you guys can get a free contract at no charge. So, Andrew, talk to us. What are the main, is it true that you can write a contract on a napkin and it can be real?
Absolutely. So the only requirement that you've got for a contract, as a base, is that it be in writing. Statute of Frauds requires that a contract for real estate is in writing.
Okay.
You just can't come up and shake a hand and say, hey, I'm going to do this under very extreme circumstances. Would that even hold up? But it's got to be in writing. And that doesn't have to be, there's nothing magical about it. Okay. You can put it on a scrap piece of paper. You can put it on, a yellow pad. Yeah. Your kids' lined papers on their spiral.
Or the chewed out homework that the dog ate.
Anything in writing that has all the necessary terms. It depends on what the content is.
Got it.
But it can even be on a napkin. In fact, there are cases that we learned in law school about agreements that people made on a napkin, and it wasn't the fact that it was on a napkin that threw it out, but maybe that the guys were drunk when they signed it. So whether they had the capacity to do it at the time, that was the issue, not that it was on a napkin.
Understood.
So it's first that it's got to be in writing. Okay. And there's nothing magical about it. You just put down, and you got to have a few things that are on that. Okay. One is that you've got to have an agreement to buy and sell. If something's in writing and you're not really explaining what you're doing, how are you to say that that's the agreement if it's just like, Andy, Andrew, 123 Main Street, $500. You got to go into what are you doing? Okay. I'm going to sell it. You're going to buy it. You get that agreement. Okay. Then you go into
number one,
what you're going to do. Okay. What is it for? Identify the property.
Got it.
Now, most people are putting down it's convenient. You put down a street address. Don't just rely on that. If you, ideally at the top, you're going to have a full legal description describing that property. Right. At second best, you're going to have maybe an address, at least the street. Okay. You're going to identify the county. You're going to identify the city. But as much information as you can put down, tax ID number is even better. Good. But there are some situations where that's not really good enough. Okay. In fact, we had one recently where they were identifying the street number, but they were, half the people under the deal were thinking that it was the empty lot that was 60 feet wide. And the end buyers on the deal were thinking that it was the house next door that had 150 feet. Right. So people dropped off, and that's the other thing. It's a meeting of the minds that they have the same idea. Okay. I'm going to buy this property. I'm going to buy it under these terms. Got it. So identify the property. Got it. Then you're going to identify the names of the parties involved, and you really should, put some effort into making sure that just the guy that answers the door when you knock there and says that they're going to sell it to you is the right guy. The right guy. He's not the only one on title, right? If that's the case, if it's him and his wife has to agree to it too. Maybe he's the tenant and he's just, anyone that knocks by, sure, I'll sell it to you for $50,000. But it should be names of the parties. Okay. And one of the pet peeves that a lot of closing attorneys have is that if it's a company put the name of the company down. If
Okay.
you're buying in the name of your company, if it's and we won't for the video,
Right.
whatever
Sure.
company LLC that you have,
Yeah.
but it should be, you know, Andy, member of the LLC.
Understood.
That's
Right.
how you
That's
sign.
right.
So
That's
if it's ABC Realty Company, you don't sign ABC Realty Company. You sign, you know, Andy. Sign your name,
Sign
unless
your
we
name.
want to change your name.
member.
Right, of that company.
Got
So
it.
identify the
Okay.
the parties to the deal.
Okay.
And then you got to name your sales price. How much are you going to pay for that property, under what terms? You typically are going to say, look, you're going to pay $100,000 in U.S. currency, paid in cash at the time of closing. The terms also might be, you know, if you're doing owner financing, that those are the terms, or it's a subject to,
Okay, yeah.
if you're taking those out of the sales price.
Gotcha.
But put a dollar amount to that.
Okay.
Even if it's, you know, in some cases, look, if there's worthless land, it might only be $1.
Yeah.
It might be $100.
Okay.
But that's that agreement between the parties. And then you got to identify a closing date.
Gotcha.
You cannot have a valid contract without a closing date, because at some point, you know, you think in the mindset of two people that they get along at the time of signing the contract. But if there's a dispute and they got to be in court, what is the court going to say? You know, that, you know, I thought they were going to close next week. Andy thought that they were going to close in July.
Yeah.
So he's going to sell it to somebody else in March when it doesn't close.
I got you.
So put a closing date down.
Okay.
You can even, you know, you want to narrow it down. So if it's not going to be a specific date, you can put, you know, 30 days from the date of this signing, or 60 days, 90 days, or a week after your 14 days of due diligence.
Yeah.
Something to be able to calculate that out.
Nice.
Even the sales price for property, when I deal with raw land, you can put a dollar amount, or if we're doing in our due diligence, something like the acreage, and we don't know what the acreage is. It might be 2 acres, it might be 4 acres. So I could put down that I'm going to pay $50,000 per acre, and then and then in the special stipulations or other parts of the contract, I might say that I've got, you know, 30 days to do a survey, and once the survey comes out, then I've already got the terms to calculate what that sales price is. But that's really all that you need. If you can squeeze that into a napkin, you know,
this is it.
By all means, you know, that's fine. But most of the time, it's not. And then, you know, but that's the basics for it. So, and I know there's some investors out there that put it on one page, you know, but then the other questions kind of come into it.
And
like,
this is great.
Yeah.
Your contract is solid, bulletproof. You have, I mean,
we went over everything. You know, a lot of people, one of the things, I'm sure there's some people listening that says, you know, what about earnest money?
Yeah.
Earnest money in Georgia is not required. And what I always tell people, it's a business decision.
Yeah.
You know, it's, you know, what's the big deal if you put down $100 versus, you know, $10,000? You know, when I've bought property before, and I think that I'm in competition with somebody else, I'm going to want to show the biggest hand to these people to say that, look, I'm a serious buyer.
Of course.
So if I know that I'm buying a property within 2 weeks, then, and I'm buying in cash, then I should have the cash.
Right.
So if it's a $50,000 piece of property, I have no problem giving to a closing attorney $50,000.
Right.
And I know that if you and I are competing for a property, and you say that you're going to pay $50,000 for this, I'll pay $50,000 for it. You're going to put down $100 of earnest money. I'm going to put down $50,000 worth of earnest money.
And you're going to win that deal every time.
I mean, who's got the better offer?
Right.
And that's one of those things where I'd say, you know, you can play that and still secure your position with your due diligence or other terms. Look, if the guy can't deliver title at closing and sign a deed, then you know, I'm going to get my money back. It's not like I'm handing, and one thing I'd never do is hand the earnest money to the owner.
Guys, never. Did you hear that? Did you listen to that? Never make that mistake. And that's been happening a lot here in Atlanta, and I'm sure in other common cities and stuff. The sellers want the money in hand. And if that, usually when that happens, I mean, from experience, they have no intention of closing. They're going to take your money. And how are you going to get it back? Right? Who's the middle person?
Now, if it's somebody that you trust, what I'd say is, you know, one, I have some issues with you giving cash to somebody.
Yeah.
If you got to give them a cashier's check, you make a copy of it. Maybe you make them sign a receipt.
Yeah.
Ultimately, as a closing attorney, whether it's myself or somebody else, they're going to want on their official documents to be able to list that earnest money was given. They're going to want to see something that says that yes, it was, that you had it, that you gave it over, that they received it, that's part of that. One of the big issues that we've had for a number of years are people trying to artificially inflate the prices of property by saying, look, I'll sell you this property for, you know, $250,000. And they think that they can, you know, make an impact on the real estate records by having a $250,000 sale when the neighborhood wouldn't support it. So how do you do that? I'm going to buy it from you for $250,000, and I'm going to give you $100,000 in earnest money. So at closing, I'm really only buying it for that difference.
That's crazy.
But the real estate records would reflect that. So if I have 3 other properties in the neighborhood, then you've got some issues with an artificially inflated price that starts going into issues of
other stuff,
of mortgage fraud, you know, you're going down a rabbit hole.
Crazy.
But, you know, just make sure you document it. And at all times, if someone's asking, saying, look, you give it over to the closing attorney.
Yeah. Guys, I always give it to the closing attorney. When I do closings, you know, Gurvey is, I mean, we've been for at least 6 years as of this video. At least it's been a long time, close numerous amount of deals. Listen, real quick, guys, before we end this video, go to gurveylaw.com.
Yep.
Gurveylaw.com. Get your free bulletproof agreement. I don't know anybody that's doing this. People, your gurus, fake gurus are not even giving you this for free. And if you're buying this from Staples or from an online,
you got to be careful.
Be careful.
You know, there are contracts that you can get all over the country, all over the world. And, you know, if they're not something for, even deeds are the biggest problem, but contracts too. Make sure that the terms are in there. Read the stuff that you're using. You know, when I talk at different seminars to investors or to realtors, everybody, it's use the documents that you're comfortable with, but read them. Know what's in them. If the terms that you don't like are there, cross them out. If they need to be something else, write them in, initial it. You know, you have the ability as a buyer and as a seller to create your own contracts. The realtors that you use can only fill in the forms, and they're going to want to talk to you to make sure that everything is right. Most of the time, they're going to be limited to, at least in Georgia, the GAR forms, and those are super comprehensive. But the special terms, anything that you want, whether it be, you know, the fact that they want to throw in the appliances, or that you want, you know, the equipment and the pool shed included, you would write those into the special stipulations. And those not only add on to, but they modify anything that's hard coded. You know, one of the things that we can talk about at another time are some of the contracts are, you know, quirky things that have entered into contracts. If you want it in there, if it's relevant, put it in there. The courts are going to recognize the agreement between the parties, whatever it is. So, and that's been make or break in a lot of situations.
Guys, but let me tell you this. If you are a new investor or experienced investor, if you're wholesaling property in Atlanta or you're buying and selling, especially when it comes to off-market deals, you have to pick up a contract. And guess what? Pick it up from Gurvey Law Group. He is not charging you a single dime. But guess what? If you do get it, we hope that you use Gurvey for the closing.
Our name is in there. As the closing attorney, you'll also see some forms for assignments, some other add-ons that are for subject to closings, or owner-seller financing. So, you know, we've thought ahead of situations because we really do it all, whether it's residential, commercial, you know, standard sales, double closings, everything.
Good.
Do it.
I love it. I love it.
You rock.
Man, you rock. Crush it out. Guys, we'll see you on the next video.